I'm always curious, what motivated you to be part of the podcast?
I think any opportunity to talk about what we do, the facts of it, I love to share it. And candidly, sometimes with podcasts, you're able to learn a little bit more about yourself too.
Hopefully, I help you learn a little bit about yourself in here.
Yeah, absolutely.
Just to recap, the podcast is to help the expert witness community. I help the experts with their web design and SEO to help them get more clients. And that's where the idea for the podcast came from, to really get inside the attorney's mind. Thank you so much for being here. At the beginning, feel free to talk about you, your law firm, who you help. Think of it like your elevator pitch. Take it away.
My name's Alex Mendez. I'm one of the partners at Shrader Mendez. We do a whole gambit of things at our firm, which I think helps us on the criminal side when we have civil background and civil side when we have the criminal background. On the criminal side, we manage second degree misdemeanors all the way to capital cases. So the full gambit, murder, sex crimes, everything in between. On the civil side, we do a lot of personal injury, a lot of business to business litigation, a lot of consumer work. And it's always good to have that experience on the civil and criminal side. I think on both ends of it, because you're able to learn arguments that work on one side, you can actually apply it to the other. I will say though, I think criminal cases are more civil than civil cases, and civil cases are more criminal than criminal cases.
So the civil ones, is it because there's more emotions involved, I would think?
I think there's emotions and money's involved. I think when money and emotions, sometimes people get jaded and have a perspective that isn't realistic.
Yeah.
So I think that always plays a role in it.
Interesting. And I guess not to get too off topic, but have you ever seen in a civil case where maybe at the beginning the family was like, oh, we all love each other. And then at the end, when there's money involved, maybe they all are not so likable between each other anymore?
Yeah, unfortunately, but we've never had, I don't want to say we've never, I can't think off the top of my head a case where a family member sued another family member, but I can tell you in cases where there is a lot more money involved, or there's exposure at least to potentially having to pay money. You could tell as the case starts getting to the point of either put up or shut up, either go to trial or resolve the case. Either people want a heck of a lot more, they want a heck of a lot less, and then the emotions come in. And I feel they did this, maybe not, but it's not the best legal defense, right? Or legal argument to be made. So sometimes when the case gets to the very end or the brink, at least, that you got to go to trial or you're going to resolve it, you could tell people start getting a little more, I'll call it T-Rex arms. They want their money or they want to keep their money,
Interesting. I guess money always changes people, right?
unfortunately.
Yeah. Tell us a little bit about you. What made you get into the legal field?
That's a great question. I actually, my entire undergrad and everything, I was not steered towards law. I was a baseball student athlete at the University of South Florida. So I played ball there and I was a biomed and business double major. And the goal was always to be a doctor. And I went to Miami. There's a bridge program that you get your master's in public health. Eventually, you bridge over to medical school. And midway through my master's, I started taking some legal related class. I go, crap, I like this. I like it a lot. So I called my mom one night. I said, "Hey, I'm gonna take the LSAT. I think I want to go to law school." And she's like, "What is wrong with you? You know what?" My mom was a paralegal and she loves the legal field, but she was like, "You've invested so much time. I really like it, and it's fun because every day I get to wear multiple hats." I'm not saying doctors don't get to do that, but with our firm and our structure, the fact that we have criminal cases, civil cases, it every 5 minutes I could be wearing a new hat, right? I could be in a death penalty case or a capital case, and then next thing you know, there's been a car accident, and we got to work that up. So it's fun, the constant changing of the hats. It's a lot of fun being in court every day. Unfortunately, it's not like the movies, right? I wish it was so theatrical like the movies, but it's definitely a lot of fun.
You mentioned that your mom was a paralegal. Do you feel that if anything, she being a paralegal made you not want to get into the law field growing up, and that's why you wanted to be a doctor?
No, not really. I always just love the science behind it. I'm a science geek, so I really enjoyed that. My great grandfather on my dad's side was counsel for the president of Cuba. So we've always had law in our background. At the time, I always steered a little bit more towards the medical side. And just with exposure to things, life experiences, I go, man, I really like this whole law thing. I really like the idea of being an attorney, and it's worked out. It's been great. Fortunate that I have a great partner. I had two great former partners. We miss Kelly dearly, but great staff. We're blessed here. It's a great team, and that's what's fun. Is every day we get to come in and we're running a business, we're running a law firm, we're working to help people out, but also we get to do it with people we care about.
That's great to hear. And your law firm, did you mention what year you guys started?
I should know this better. My partner Brian, he started the initial firm probably over 15 years ago. And eventually it became Shrader Mendez and O'Connell, and then now it's Shrader Mendez. So it's been fun. We battled through the COVID shutdown and we've grown the firm a lot, and the firm continues to grow, and we're bringing in great people to help it grow. So I'm definitely excited for the future with it.
That's great to hear. I hope it goes amazing for you guys. One of the questions I had from one of the experts, and it wasn't really a question, it's something they mentioned and made me curious, is the expert said that one time an attorney called him, started asking him questions, and then it turns out that this attorney was just trying to get him conflicted, I think was the word he used, just to get him
Yeah.
conflicted on the case. And because then the actual attorney that wanted to hire the expert called him, and then he found out that now this expert is conflicted. What could an expert do when they receive a call from an attorney to know if this attorney really wanted to hire me, or is this attorney trying to do something devious here, like trying to get me conflicted or something else?
That's always a risk, right? I don't think there's any one perfect answer to say a way that an expert can insulate themselves from that, especially if it's an expert that has done both sides of the aisle, which I think for us as lawyers, if you have an expert that has been on both sides of the aisle, whether for the state or defense and plaintiff, it gives them a lot more credibility. But then it also creates that situation where both sides can reach out. And if the other side reaches out before you do, then that can create a conflict. I won't speak as to what tactics and stuff like that other attorneys do, whether I agree with those tactics or not. It's for an expert, there's always an opportunity they could try to flush out and get a vibe. Are they just trying to create a conflict? An expert could even say, look, I need to do a conflict check before you tell me anything, and then I'll call you back. And it gives them time just to see, get the vibe and see if they want to. I think in the end, the expert has a decision if they want to work with the person or not. So maybe you could do some legwork on the front end to try to flush out that conflict or flush out the idea behind it. But I think it's really tough, especially when there's experts on both sides of the aisle, or they've done work for both sides of the aisle. You're going to get calls from both sides of the aisle. So it's tough for them to insulate themselves if they rather work for one or the other.
So just talking to the attorney is not going to get him conflicted. When you say conflict check, let's say I receive a call from an attorney right now, and I'm like, hey, nice talking with you. Tell me, does just knowing about the case, if the attorney tells him about the case, is that enough to get him conflicted? Or what is involved in that conflict?
It could, right? It depends on what they ask for. If an expert calls and says, hey, have you ever been deemed an expert forensics, let's say? I think that's pretty benign. That's pretty G rated. Now, if they start going into specifics of the case, the posture of the case, the name of the case, and all of a sudden another expert calls, I just got that perspective. I can't really be an expert. So I think if it's very general information and not case specific, they may be okay. And I say may, I mean there, especially in law, there's no definite. But I definitely think when you start getting into case specific stuff and the client and information of the client and how discussions go, that could obviously cause a conflict for an expert in the future if the other side of the aisle now wants to retain them.
Let's say there's an attorney that really wants to get an expert conflicted. What if I myself, as an expert, just receive an email with all the details of the case? Is that enough to say now I'm conflicted, or can I say he sent me all of that information? I never requested it. I haven't even read the whole thing.
It's tough, right? I think just to answer that point blank, I think it'd be tough because we don't know exactly what was said. All the information saying, "Hey, I'm defending or I'm pursuing a personal injury claim," let's say, and there's an accident in our position, there's no liability, et cetera, et cetera. We don't know everything that was said. Maybe more was said that would cause a conflict. Maybe less was said that wouldn't cause a conflict. That's the tough part is we don't know in that example the totality of it to be able to say specifically, yeah, that's probably enough to cause a conflict versus not.
So it could be really outside of the control of the expert for that.
It very well could be if they get an email. And again, I mean, for the expert, professionalism, basis of it, I rather do things the right way and cross your T's and dot your I's. It's not worth pushing the limit for any one case, right? Because I think that goes to your credibility, that goes to the work you do. So I think it's always important that if you do something, you do it the right way. Whether you're able to take a case or not, you got to do it the right way.
I know you mentioned you don't really want to comment on what other law firms do, but is that something that you maybe feel it's something that the general attorney population may do, or maybe just some of them? What would you say?
It depends. I know there's experts that we have used and they've done work primarily for one side of the aisle, but we know, how they work, how they sometimes we try to get them before the other side because they are good and they are good experts and they're able to review it and all of that. So I think that's doing it the correct way, doing it professionally. It's better to be proactive than reactive. So if there's a good expert out there that's been on both sides of the aisle, you want to get them, right? Does that mean the other side can't use them? Probably, but it depends, right? That's the tough part, and it's the frustrating legal answer that a lot of the lawyers give is that it depends.
It sounds like a really big statement. Like it could change everything. Just that.
One fact could change everything. One fact, one conversation, one email, one message, any one thing could change whether a conflict was created or not. One thing could change how the case is perceived, how the case is worked up. There's a lot of little factors that I think we could talk very generally and very like hypothetically. But if you get to the nitty gritty, one thing can change sort of the direction of whether the expert was conflicted off. If they're not, what's their impact on it? So there's a lot of moving parts.
Something else I was curious about is an attorney was talking about how sometimes in court, the retaining attorney may notice the jury react in a certain way and then come up with completely new questions that were not gone over with the expert, and then that the expert may either be flexible and just answer the question straight, or it may be caught off guard, and if the expert's caught off guard, the jury notices that. So I was wondering if you have any examples of maybe when that's happened to you, like mid-court, you notice something, the jury react a certain way, the judge react a certain way, like just something happened that may have caused you to change the questioning mid-trial.
Sure. You always go into a trial or a hearing with a game plan, but game plans change. We all saw the Super Bowl last night, right? I'm sure they had a game plan and it had to shift, right? So I think the same thing goes for a trial, for an evidentiary hearing, a regular hearing. It's you go in with an idea as to what you're going to do and ideas of arguments you're going to make. But you also have to be flexible to be able to pivot because you may be going down a path thinking, hey, it's good. You catch the jury and they're like, man, this guy's a total jerk. Then you got to soften it. Sometimes there'll be an objection and the judge will rule against you. And then now you got to figure out a way. How do I get in what I wanted to get in without, getting the judge frustrated with you or having another objection raised? And that's normal. That's very common. It's very normal. I've got trial set on Thursday and we have a plan, we have an idea, but it may pivot, right? They may answer a certain way that we weren't expecting, and then you got to pivot. So I think when you have experts, it's also important to try to think about as many what if scenarios. If this happens, then we're thinking about this. And a lot of times when we speak to our experts, we never tell them what to say. They're the expert in that. That's for them to say. But I think The other side is going to try to elicit this. The other side is trying to make this argument. Be cognizant of that. And then when it comes up in depth, oh, yeah, see, we were right. Sometimes we think, hey, they may try to go down this path and they're very G rated and nothing comes of it. But it's being able to have that open communication with your experts on the front end to say, hey, this is the purpose that we're retaining you. This is what we're looking at. Please give us your opinion. If that's your opinion or not, how do we present that? What's the best way to get that across? And especially with experts, they're experts in the field, but you got to talk to a jury like they're 5-year-old kids, right? You have to explain it in that way. So it's very much having that communication with them to be able to say, okay, how can I communicate this in a question and answer type of scenario for the jury to understand? Because if you talk technical and I talk technical, they're going to look at us like we have 10 eyes, right? So we got to be able to have that conversation with them and be able to say, hey, what is this? Okay, can you explain that? What does this mean then? What is this impact? And spread it out. And I think that helps. But you have to be able to have that open communication with your expert on the front end to be able to know, hey, I can pivot midway through trial or midway through a hearing or cross or direct to be able to say, hey, this is where we are. So that's the biggest thing, is being able to have that open communication with them.
With this open communication and going to court or depot with a game plan and being flexible, is there anything like over preparing? How do you know you're preparing enough, but also maybe not go into, okay, we're going into literally like 1,000 different scenarios, like spending a lot of in over preparing?
I don't think you could ever over prepare. Right. But it definitely gets to a point when you have to be able to sit back and say, all right, that is so far out in left field that if that gets asked, we've got a lot of bigger issues. So I think it gets to a point, and the more you do certain cases, if there's a case involving a gun, you have ballistics, firearm experts. The more you do it, the more you know what each side is trying to elicit from the testimony, right? Same thing on the personal injury side, the consumer side. Are they trying to show the policy procedures? Was there causation? Was there not? So you have an idea as to where it is. There's always those unicorns in the room that you're like, man, this is so unique in a league of their own. We really got to hone it in and we really got to try to keep everything on track. But generally speaking, I don't think you can ever over prepare. Can you overthink it? Absolutely. But I think that's where you've got to sit back and say, is that even reasonable? Is that even a plausible scenario? If it's not, you're probably okay. Keep it in the back of your mind, but the likely of it coming out is probably slim to none.
Something interesting I was watching is sometimes there's like cases where someone got accused of murder, triple murder, right? So many murders. And then 20 years later, they find something that could exonerate them, right? Maybe a phone that shows their location, he was in a different place, or just something else, or maybe new technology. I guess when DNA came out, right? When new technology, they could test their DNA. How does the difference in technology work? Like, for example, let's say there's a case where someone got accused of murder, they find their phone from 20 years ago. The data from 20 years ago is different than the data now. So I guess I'm curious, how would you, I know they will probably bring a new expert, right? And do you have any situations where you've had that happen?
I have had a murder trial where the cell phone, unfortunately, was the straw that broke the camel's back. But I think it's a great thing about science. It's always evolving. So science is getting better. The mechanisms to evaluate cases are getting better. Are there still mistakes? Absolutely. It's human error. We're all human. There's going to be mistakes. Unfortunately, sometimes it's at the detriment of accused. People have served very lengthy prison sentences, have been on death row, they've been exonerated. So I'm fortunate that the science has developed to be able to help those people. But science is constantly evolving, it's constantly being improved. There's better mechanisms to preserve things. So, is there a possibility that there could be future sciences or future mechanisms, future programs to be able to minimize the risk of being falsely accused? Potentially. But I think that's just inherent when, you get called to a crime scene, you try to preserve the evidence as best as possible. Can something go awry? Sure. I'm not okay with that, especially being a criminal defense attorney, but that's part of it, and that's where you need to have you get your proper team, your investigators, all your proper experts. And sometimes you're able to get that, right? Sometimes there's sex crimes, you need forensic experts. There's so many different experts that you could use. But to answer your question, I think, yeah, it's a great thing that science is evolving. And obviously, with DNA, that's exonerated a lot of people. There have been new tools. I think bite marks have been disproved, and that shows some people were exonerated for that. So there's a lot of things that have helped people that were wrongly accused or wrongly convicted for that matter. But I think as we see science and technology evolve, there's probably a possibility we may see more of it, right? Because there's a lot of things that we potentially can't test for today, but in 10 years may be able to, right? So then that changes. Does it change where things were? How do you address it? Yeah, there's new experts because there's new science, there's new people that are involved in it. So it's a constant revolving door, right? With the improvement of science, with the improvement of technology, I think we're going to continue seeing that.
Hopefully, save some other people that may have been.
That's the goal.
I was gonna ask. I've heard of the term red herring, right? When it seems like when they try to just misdirect focus from the real issue. And for example, is let's say if I'm at the dog park and dogs bite me, and now I'm suing this person, they're saying like it wasn't my dog's fault, it was the pants' fault because they shouldn't have ripped. So that's what caused your skin to pierce, or you shouldn't have been standing there. Is that commonly seen in a lot of cases where shifts blame to something that really doesn't, just to, I don't know, extend time, extend costs, things like that?
It could, yeah. You get a lot of like the but for arguments. But for this wouldn't have happened, or but for that, this happened. So, is it a common tactic to try to change the perspective of a jury? Sure. You're trying to get your argument across, right? So, one side may say it's this one route, the other side's going to say it's another. And obviously, you have different burdens on a criminal versus a civil case, but it's not always necessarily a red herring type of scenario, but it's more creating a narrative that fits what's available, right? In a murder case, let's say, if you don't have the gun, if you don't have witnesses putting the person there, it could have been somebody else. So, could you consider that a red herring? Sure, because you're trying to point it at some random person. But in reality, that's just the truth. In reality, it's not for the defense to disprove or prove, it's for the state to prove it beyond a reasonable doubt. Sometimes what appears to be a red herring is just simply stating, hey, there's other plausible and reasonable things that could have happened versus saying it's unequivocally this.
Would it be a red herring when it's what we were talking about, a completely maybe not very realistic scenario? Or if they bring this up, then there's bigger issues. If I'm standing on the sidewalk and someone runs me over and they try to blame me for standing there, would that be considered more of a red herring?
I don't think that's actually a red herring. I think that's just a position they're taking.
Okay.
You say you're on the sidewalk, but you're a foot off the sidewalk, and it's stuff like that. I think the red herring is just something that's so far out in left field that it's like, what the heck are you even talking about? It's something that's just to me. I look at a red herring in a way that that's like what, right? It's like you throw your hands up and you're like, what are you even talking about? This makes no sense. So to me, that's more red herring. Arguments can be made. You said this or you said that, and you call into doubt. But I think the red herring is more something that's so far out in left field that really has no basis that people throw their hands up and they're like, "What are you even talking about?"
Yeah, it's absurd. I had a more of a specific question. Let's say you're looking for an expert outside your network, so you have to go find one online. Sometimes experts, they're wondering if they should have more of a a company corporate name, like for example, engineering consultants, forensic engineering consultants, let's say, or if they should portray themselves as a solo expert, like Smith's forensic engineering.com. If you're looking for an expert for your case, does either of that matter? Like if the content inside of both looks good and you're like, okay, this company knows what I need or this person knows what I need, does it really matter what they portray themselves at?
I know what I don't know, and I don't know enough about SEO to give you a definitive answer. I can tell you when we're searching out experts, I like to talk to other experts and say, hey, do you have anybody that you recommend? If you go, for example, to a cardiologist, but you've got an issue with the electrical circuits of your heart, you want a cardio electrophysiologist, you want a very specific doctor. I want to know who the doctors recommend, right? So I want to know, same with the experts. If we go to a forensic expert that says, oh, I do forensic work and we've done work in the past, but it's a very niche avenue or niche problem or issue, I want to talk to that expert and have him tell me, hey, no, go talk to John Doe. That's your person or that's your gal, right? That's the person you got to talk to because they know that inside and out. So I think the name as to how it's presented for me, it wouldn't impact me. Now, SEO and all that stuff on the back end, that's for a marketing expert. That is definitely not me. As much as we try to learn it, I feel sometimes it's like a witch science. But I think definitely the recommendations of other experts is important. I'll give an example when it comes to competency. Sometimes if you do it independently, you want to get multiple opinions, right? Just to verify a competency issue in a criminal case. A lot of times we'll have a doctor that we trust, and when we go and get additional people, then we'll say, hey, who do you recommend? And they'll say, hey, I recommend these three people. Great. Or hey, I need a bilingual expert. Cool. Who do you recommend? I recommend this person. So getting that validation from other experts that do the work is really important.
Word of mouth, right?
Yeah.
Is there any parting advice that you would give to any experts?
Be honest. Don't let an attorney dictate what you want to say or have them force you into saying what they want to hear. It's important that you're very neutral. Obviously, you're being retained to give an expert opinion, but don't just say what you want attorneys to want you to say because then when you go testify, it's going to impact your credibility. And without your credibility, you have nothing. So I think being available, being reasonable, being understanding, being willing to listen, I think those are all key. I think we should do that in the world in general, right? But I think being open to have discussions with the attorneys is, hey, this is what I'm seeing. I know you're the expert, but this is what I think could be a route. What do you think? And be able to have that dialogue because then it puts the attorney at ease saying, okay, they listened, they understand what our position is, but also giving them the ability to do their job, right, as the expert. So I think definitely being open, having open communication. And for me, I love seeing experts that do work on both sides of the aisle. Personally, I know there's a lot of experts that are defense driven, a lot of experts that are plaintiff side driven. I think when you do both sides, I think a jury sees you more. I think you're more marketable and you have more credibility when you speak because either side can say you do 97% of your work for the defense or you do 98% of your work for the plaintiff. Yeah, you're obviously going to give an opinion that favors that, but that'd be 50-50. But if you have work on both sides of the aisle, I think that gives you a lot more credibility.
Thank you, Alex. Thank you so much for that insight. Thank you for your time here. I'm sure a lot of experts and attorneys also are going to enjoy watching this. So thank you so much for being.
Of course. Yeah, thanks for having
So, Alex, again, thank you so much for being here. But the episode, it's taking me about 6 weeks to get it live. So it's going to be live in 6 weeks. At the beginning, I ask more questions about you. So I try to create some reels, like really just about you, right? You, your company,
Right.
what you do, to so you have some content to share as well. So I'll share that as well in the 6 weeks. But other than that, again, thank you so much for here,
Of course. No, appreciate it.
of course. All right, I'll let you go. Bye, sir.